morning, Your Honor. This is Laura Williams, certified interpreter.
Good afternoon. Is Rainiel Perez? Also, for the record, would the attorneys please state your presence?
Juliana Palmieri on behalf of the state.
Letitia George on behalf of the Office of the Public Defender.
All right, thank you. And as I mentioned earlier, I will be appointing the public defender on all cases. The public defender should let me know if there's a case where the public defender believes they should not be appointed. Ms. Is Rainiel Perez the interpreter?
Yes, Your Honor.
Yeah, she's on there. Just trying to see, why didn't I write something on this file? Okay, I do find probable cause for the offense of battery, dating violence, and we'll set a bond in this case at $500.
Your Honor, he does qualify for PTR.
PTR as well, okay. Yes, I see. All right, let's go ahead on and swear in the victim.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God? Do you need an interpreter?
No.
Okay, do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Alicia Diaz.
All right, State, do you have any questions for the victim, Miss Alicia Diaz?
Yes, Your Honor. Ms. Diaz, what is your relationship to the defendant?
He's my partner.
And are you afraid of him?
No.
Has anything like this occurred in the past?
No.
Would you like to have contact with him while this case is pending?
Yes.
Would you feel comfortable calling law enforcement if this were to occur again?
Yes.
Do you believe alcohol or drugs were involved in this incident?
No.
Is there anything else you would like to tell the court?
No.
Thank you.
Further questions?
All right. Defense, you may inquire.
No questions, Your Honor.
All right, the court will order pretrial release, no hostile contact with the victim, no possession of weapons or firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Madeline Rosado.
And Ms. Rosado qualifies for PTR, Your Honor.
All right, thank you. Does Ms. Rosado need the interpreter? Ms. Rosado, you speak English? Yeah. You speak English, Ms. Rosado?
He stated yes, Your Honor.
Yeah, she did state yes. Ms. Rosado, the court finds probable cause for battery, domestic violence. Do you understand that? And I am setting bond in your case at $500. I'm ordering that you have no contact with the victim in this case, that you possess no firearms or weapons, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of release. Thank you, ma'am. Andre Hernandez Bautista. William Jermaine Hampton. Mr. Hampton, the court finds probable cause for aggravated battery on a pregnant person. Bond is set at $3,500. The court is ordering you to have no contact whatsoever with the victim in this case, that you possess no firearms or weapons, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Michael Bennett. Michael Bennett, okay. Michael. Okay, the next one, Francois. Michael Bennett. Okay, you can go ahead and call language line on on Francois whenever we get to him.
I'm sorry, Your Honor. Will the interpreter still be required or may she?
Michael Bennett. A court finds probable cause for trespass on property bond stays at $500. The court is revoking.
Your Your Honor, I believe there was an offer to resolve both of his cases today. We were appointed on his out on bond case, Your Honor. There was already an offer to resolve that case. I believe the state has offered to resolve both, Your Honor.
The state's offer would be for the trespass, a withhold court costs, no return to scene, and credit time served.
Well, that's unacceptable to the court. The withhold is unacceptable.
It's a adjudicated.
It was initially an adjudication. There was another case with another ASA that offered the
The withhold is unacceptable
okay.
to the court. So if he doesn't want to take it, that's fine. The resisting, what's the offer on that? She said he's pleading on both of them.
Right.
So I'm not going to give him a withhold on both of them.
The other offer from the other ASA, I believe, was a withhold court costs and cost of
It's
prosecution.
not.
Your Honor, we're okay with the adjudication.
All right. I'll adjudicate him guilty. I'll withhold on the first case and adjudicate him on the second case. And by the first case, I mean 21 MM 8033.
Okay.
I will need a factual basis state because I don't have any information on that case. If you have it, I'll need it from you or from the defense. Obviously, I have the factual basis on the trespass because I have the paperwork for that.
I have it on the trespass.
I have it on the trespass. I don't have it on the resisting.
I can try to pull it up. I don't have the resisting in front of me.
Defense, do you have these factual basis or are you going to just stipulate to a factual basis this
Yes.
morning?
Yes, Your Honor. I will stipulate to a fact.
All right, okay, thank you then. All right, how does your client wish to enter his plea to the charges of resisting an officer and trespass?
No contest, Your Honor.
All right. Can I get the plea form?
Yes.
Sir, is this your signature here on the bottom of this plea form?
Yes, it is, Your Honor.
Did you read this plea form in its entirety, sir?
Yeah.
Was your attorney able to answer all of your questions to your satisfaction regarding your plea of no contest to this charge?
Yes, she did.
Are you under the influence of any alcohol, drugs, and medicine today?
No, ma'am.
You understand by entering your plea of no contest, we will be resolving the case today. There will be no trial in this case. You understand there will be no future hearings in this case.
Yes, ma'am, I do understand.
The court, and sir, do you understand a conviction on these cases will subject you to deportation if you're not a U.S. citizen? The court finds that there is a sufficient factual basis to accept your plea as to the trespass charge. And the court, defense has stipulated to a factual basis as to resisting. So there's a sufficient factual basis for the plea. As to both charges, you are alert and intelligent. As to resisting, I will withhold adjudication of guilt, order credit for time served, and order no court costs. As to the trespass charge, I will adjudicate you guilty, order you not to return to the location where this incident occurred, order credit for time served, and order mandatory court costs. All amounts must be paid to the clerk's office within 180 days of your release. I am releasing you as to this charge or these charges. If you have any trouble making the payments on the court costs, then you must report to the clerk's office for a payment plan, or you will be, your license will be de-sixed and you will be transferred to a credit collection agency. Do you understand? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
Thank you, Your Honor.
Francois Blantrade Larry Joy.
Sorry, Your Honor. The interpreter would like to know if she's not required anymore, if she may disconnect.
I don't know. Can someone tell me?
Yes, Your Honor, that was all in Spanish.
Was that it?
Yes.
Apparently that's it, Laura. Thank you.
You're welcome. Have a nice day.
You do the same. Are you Laura Joy? All right. This one that needs the interpreter. Pass that case. I'm passing that case. Daniel Stephen Bush.
And Mr. Bush does qualify for PTR, Your Honor.
All right. Mr. Bush, you have two cases. The court does find probable cause for the charge of battery. The court also finds probable cause for the charge of obstruction. Is this witness here for Mr. Bush? Swear in the witness.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
Laura Tyndall.
No, I didn't hear her.
What's your name?
Laura Tyndall.
State, do you have any questions for Ms. Tyndall?
Yes, Your Honor. What is your relationship to the defendant?
My fiance.
And are you afraid of him?
No.
Has anything like this occurred in the past?
Yes.
How many times?
Quite a few.
Would you like to have contact with him while this case is pending?
No.
And if this were to occur again, would you feel comfortable calling law enforcement?
Yes.
No further questions, Your Honor.
Defense, do you have any questions?
No questions, Your Honor.
All right. Bond is going to be set at $2,000 in the obstructing case and $500 in the battery case. The court is ordering no contact whatsoever with the victim. The court is ordering possess no weapons or firearms and surrender any weapons or firearms in your possession to law enforcement within 24 hours of your release. The court is not going to order PTR in this particular case. Actually, the court will order PTR in this particular case, along with both bonds. Both bonds in both cases. Both cases, both bonds, both cases, PTR. Same conditions, both cases. Ma'am? Thank you. Glenn Ira Gaines. Mr. Gaines, the court finds probable cause for attempted kidnapping with a firearm. Bond remains at $10,000. Aggravated battery with a firearm. Bond remains at $3,500. Battery by strangulation and dating violence. Bond is set at $500. Criminal mischief bond remains at $250. The court is ordering no contact whatsoever with the victim. Possess no weapons or firearms and surrender any weapons or firearms in your possession to law enforcement within 24 hours of release. Thank you, sir. So what we'll do is try language align again, and if we can't get them, then we'll be resetting Ms. Francois' case. Lauren Joy?
proceedings. Just need you to try-
All right, let's bring Ms. Lauren Joy back. Is that going to be on speaker? Why is it ringing? Is the interpreter on the line?
Yes, I am. Good morning.
Good morning, Ms. Laura Joy. The court does find probable cause for the charge of battery on a person 65 years of age or older.
Okay. Did you want me to speak to the defendant?
Well, can you translate to Haitian Creole what I'm saying to the defendant? All right, so
Yes.
when I talk, please translate it to the defendant for me. Ms. Laura Joy,
Certainly.
the court does find probable cause for the charge of battery on a person 65 years of age or older.
Madame Marvet, juge la dit que il y a une cause probable que ou fait un monde, ou bat un monde qui 65 ans ou plus.
Bond remains at $2,500 for that count.
Il dit comme ça que une caution qui $2,500 pour ça qu'on fait.
The court also finds probable cause for battery.
Il dit, là, il voit que probablement côté bay moun nan kou. Tribunal là, il y a une cause parce que te fait moun mal, te bat moun.
Bond remains set at $500 for that count.
Et caution pour ça, c'est $500.
The court is further ordering that you have no contact with the victim in this case.
Et tribunal là dit tout, pour pas gen ken forme de contact avec moun nan, sous kasa.
I am also ordering that you possess no firearms or weapons.
Il dit comme ça que, le juge là dit comme ça que, la dit pour pas gen ken zam, sous.
And that you surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release.
Et là, la go là, n'importe qui bail qu'on gagne la caillou. Vous comprenez? Pour bail police li.
Thank you, ma'am.
You're welcome. Thank you for using our service.
All right. You may disconnect.
Okay, thank you.
Jennifer Marie Rosado Bennett.
He's in the hospital, Your Honor.
Reset as defendant is in the hospital. Candido Rosario.
And he does qualify for PTR, Your Honor.
Mr. Rosario, the court finds probable cause for battery, domestic violence, and bond is set at $500, and tampering with the witness bond is set at $2,000. The court is ordering that you have no contact whatsoever with the victim in this case. The court is also ordering PTR as to both counts. That you have no contact with the victim, that you possess no firearms or weapons, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release.
Your Honor,
Yes, ma'am.
can we have a one-time return with law enforcement? All of his belongings are there.
The court will allow a one-time visit in the presence of law enforcement to retrieve personal belongings. Kevin Lewis Anderson. The court finds probable cause for battery, dating violence. Bond is set at $500. Battery bond is set at $500. Criminal mischief bond is set at $150. The court is ordering no contact whatsoever with the victim. The court is ordering that you possess no firearms or weapons and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release.
Your Honor, what was the bond for the criminal mischief? I'm sorry.
I don't remember.
150. Thank you.
Stephen Bernard Barnes. The court finds probable cause for battery, dating violence. Bond is set at $500. The court is ordering no contact whatsoever with the victim. You possess no firearms or weapons and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Govan Jason Kondaya.
Thank you, Your Honor.
Mr. Kondaya, the court finds probable cause for battery, domestic violence, and bond is set at $500. The court is ordering that you have no contact whatsoever with the victim, that you surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release, and that you possess no firearms or weapons as a condition of your bond. Christakis Kompoulos.
And Mr. Kompoulos qualifies for PTR.
The court finds probable cause for battery, dating violence. Bond is set at $1,000. The court is ordering that you have no contact whatsoever with the victim, and that you possess no firearms or weapons and surrender any of your possession to law enforcement within 24 hours of release. The court is also ordering PTR as a condition of bond.
And Your Honor, on the previous case, can we have a one-time return with law enforcement? He has items at the house.
You can file a motion on that.
Oh, well, the current client, he has items at the house as well. Did he have a one-time return with law enforcement?
The court will allow a one-time visit in the presence of law enforcement to retrieve any personal belongings. Armand Keith Brody. The court finds probable cause for video voyeurism, and bond remains set at $5,000. The court is ordering no contact with the victim, possess no firearms or weapons, and surrender any of your possession to law enforcement within 24 hours of your release. Christopher Celsus. Court finds probable cause for possession of cannabis with intent to sell or deliver
And
with
Mr. Celsus does qualify for PTR.
a weapon, and the court is ordering a bond of $20,000 with PTR, as well as open container. The court finds probable cause. Bond is set at $250. No PTR on count two.
You said 20,000?
20,000.
Since he does qualify, I would ask, and his last charge was in 2018, I would ask for a reduced bond on count one if we're gonna place him on pretrial release. He's been in the Orlando area for over a year and currently employed. He has 0 failures to appear.
What says the state? Any objection?
The state has no objection, Your Honor, based on his record.
All right. What is the state's suggested reduction in the bond?
I would leave it in the court's discretion. I would ask for a reasonable bond based that he doesn't have any failure to appears. I would leave it in your discretion.
I'll reduce the bond in the case to $5,000.
Any conditions with that case, Your Honor?
No. Marcus DeWitt character.
He's mental health, Your Honor.
Reschedule.
I'll waive the appearance, Your Honor.
All right, the court finds probable cause in Mr. Character's case for criminal mischief. Bond remains at $1,000. Vasily Florianovic. Court finds probable cause for first case burglary of a structure. Bond remains set at $3,500. Armed burglary bond remains set at no bond. Grand theft bond remains set at $500. And the second case, bond remains set at $3,500. The court finds probable cause for burglary of a structure, and for count two, attempted burglary of a conveyance. Bond remains set at $1,000. The court is ordering revoking the bond in the case number 2021 CF 14700. bond is set at no bond.
Were you referring to the out on bond case, Your Honor?
Yes, ma'am.
That's 2021 CF 007952AO.
Oh, sorry, I made a mistake. You're correct. That is the case where the court is revoking the bond, the case number that the clerk, the court personnel just said. Albert Gilbrief, is this person the same as the next person, Lawrence Govan, or are they different?
They're different, Your Honor.
Well, then I don't understand this paperwork, because it seems like the same actions that were attributed to Albert Gilreath are also attributed to Lawrence Govan. So unless you all want me to read it again, can you explain to me what's going on here, State? Why it looks like it's the same, that the officer is characterizing all actions as to one person? I can find probable cause for Albert Gilreath, but I'm not sure I can find probable cause for Lawrence Govan. As to Albert Gilreath, the court finds probable cause for carrying a concealed weapon. Bond is set at $1,000. 4 counts of resisting an officer without violence. Bond is set at $150 on each count.
Your Honor, I would ask for, on 3 of the counts that he is ROR, given that it did stem from the same single incident. So I would ask for a bond on the first count and ROR on the next 3 counts of resisting. It's the same.
Well, I already reduced it, and the recommendation was $2,000 all total, and I reduced it to $150 each count. So I'm just gonna leave it like that. The court is ordering that you possess no firearms or weapons and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Now, as to Lawrence Robert Govan, State.
Your Honor, Mr. Gilreath also had an open case.
I'm sorry, he did? I didn't get that.
2021 CF 009828AO. 2021 CF 009828AO.
What was the charge in that
For
case?
fleeing and attempting to elude.
All right, if that case is still pending, I'm gonna revoke the bond on it. Can we confirm whether that case is pending?
He was sent to pretrial diversion, Your Honor, so.
Well, I'm gonna revoke the bond. If there was a bond, and if it was PTR, I'm gonna revoke PTR, and if it was ROR, I'm gonna revoke ROR. I'm revoking whatever he had.
And is he being held at no bond for that case, Your Honor?
There will be no bond. But I just want to confirm that the case is still open.
It is, Your Honor. He was referring
Right.
to PTD just a couple days ago.
All right. Revoke release status in the previously pending case. All right, State, can you explain to me, and it's quite possible that I misread it, so, but I just.
Your Honor, you're correct. It seems to be the exact same affidavit as Mr. Gilreath.
Well, it could be the same, but there should be something in there that tells me what Mr. Govan did as opposed to Mr. Gilreath. And it seems that every single thing that the officer has arrested somebody for, he attributes it all to Mr. Gilreath. But then this case, Mr. Govan's name is on it. So I just don't understand.
The state would just ask for a 24-hour reset so I can reach out to the officer and see if there's maybe a supplemental report.
All right. Yes, ma'am.
If you look at the end, I believe it's the end of the arrest affidavit.
The end of the one for Mr. Govan?
It states it at the end. He starts talking, because at first, I believe it was a different name.
Mm-hmm.
Oh, I see it.
Yeah, he
Yes.
provided a different name, and then at the end, he realized that his name was not.
Yes, he was identified as Lawrence Robert Lee Govan.
And I believe he had the cannabis. Because he had the out account, he had an active warrant. And I believe the officer found the cannabis.
Okay, well, there you have it. That's what happens when you go telling somebody you're somebody different. Then it confuses the judge and you almost don't get your initial appearance done. But yes, I see that. And deputies, please do not bring anyone else in after him because I need to take a break. Mr. Govan, I am finding probable cause for possession of cannabis. Bond is stayed at $1,000 and providing false ID to a law enforcement officer, and bond is stayed at $500. Yes, that's right. And the court does also find probable cause for burglary of a conveyance. Bond is stayed at $3,500. Grand theft bond stays at $1,000. Assault bond stays at $250, and battery bond stays at $500. The court is ordering you have no contact whatsoever with the victim in these cases, and that you possess no firearms or weapons and surrender any firearms or weapons to law enforcement within 24 hours of a release. Court's going to take a recess. Yes. Court finds probable cause for attempted second-degree murder with a weapon. We're back on the record. With the state and the defense counsel, please announce your presence for the record.
Juliana Palmieri on behalf of the state.
Letitia George on behalf of the Office of the Public Defender.
All right, Charles Griffin, the court finds probable cause for attempted second-degree murder with the firearm. Bond remains set at no bond. Shooting or throwing a missile into a dwelling or structure or vehicle. Bond is set at $2,500. Count 3. Shooting or throwing a missile into a dwelling or structure or vehicle. Bond is set at $1,000. Discharging a firearm in public. Bond is set at $100. Carrying a concealed firearm. Bond is set at $100. The court is ordering that you possess no firearms or weapons as a condition of bond, and that you surrender any firearms or weapons to law enforcement within 24 hours of your release. Rafael Bolivar Idrovo. The court finds probable cause for possession of firearm by a convicted felon. Bond remains at $4,000. Possession of ammunition by a convicted felon. Bond remains at $150. And possession of cannabis. Bond remains at $150. Court is ordering that you possess no firearms or weapons and surrender any in your possession to law enforcement within 24 hours of your release.
I think
This is not the individual, Your Honor. This is Matthews.
Well, you all need to bring me who is next. I mean, I don't know who it is. I just know that I called
What was the name of the next individual, Your Honor?
Idrovo, Rafael Bolivar Idrovo.
Do you have a booking number for them, Your Honor? They might have bonded.
21026508.
They bonded.
Jamie Matthews. The court finds probable cause for trespass in a designated construction site. Bond remains at $1,000, and grand theft bond is set at $100. Michael Mosley. The court finds probable cause for Mr. Mosley. The court finds probable cause for attempted sexual battery on a person 18 years or older. Bond remains set at no bond, and false imprisonment. Bond remains at no bond. Battery bond is set at $500. The court is ordering no contact with the victim whatsoever, that you possess no firearms or weapons and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release.
I believe he's entitled to a bond. Is this a PBL? I didn't think it was a PBL. A punishable life offense. I believe he's entitled.
The court's going to continue with the court's order of no bond. You can file a motion if you want to get a bond. Arthur Christian Murray. Mr. Murray, the court finds probable cause for aggravated assault with a firearm. Bond is set at $2,500. The court is ordering no contact with the victim whatsoever, and that you possess no firearms or weapons and surrender any in your possession to law enforcement within 24 hours of your release. Sheldon Pierre.
Mr. Pierre does qualify for PTR.
All right, the court finds probable cause for grand theft of a motor vehicle. Bond is set at, the court will order PTR in your case and set bond at $250. $250 plus PTR.
Any conditions on the case, Your Honor?
No. Zachary Aaron Teal. The court finds probable cause for Mr. Teal, burglary of an occupied structure.
Your Honor, I did have a PC challenge for the burglary.
For Teal?
Yes, Your Honor.
All right.
Give me a second. Your Honor, in order to prove a burglary of an occupied structure, the state must prove he committed offense other than just the burglary. I would argue that there's PC for a trespass, but not a burglary of a structure.
What says the state?
Your Honor, the state is in agreement with that. It appears that he just went inside the bathroom, not that he had any intent to commit any other crime. The state would ask the court to find PC for a trespass, but not so much for the burglary.
Is there such a charge as attempted burglary? State, because the facts of this case trouble me greatly, more so than I would want to find probable cause for misdemeanor trespass.
Do you have the jury instructions? I think there may be. If I'm not mistaken, there is.
I'll find probable cause for attempted burglary. Bond is set at $1,000. Court is ordering no contact with the victim, no return to the location where this incident occurred, possess no firearms or weapons, and surrender any of your possession to law enforcement within 24 hours of your release. The court is further revoking the bond, and I'm not sure the case number, but there's another case on Mr. Teal.
From Osceola County, Your Honor. He was just ROR'd yesterday, so I don't think they had a case number to provide us with yet.
Well, I'm revoking the ROR from the case from yesterday. No bond. Michael Leon Welch. The court finds probable cause for possession of a concealed weapon or firearm by a convicted felon, bond remains set at $5,000. Possession of firearm or ammunition, bond remains at $150. Dealing in stolen property and bond remains at
Your Honor,
$150.
Again, I think this is Mr. Urema, not Roche.
We don't have a Welch on our docket.
You don't have a Michael Leon Welch?
Do you have a booking number for them?
6509.
They bonded.
Jonathan Buckley Urema. The court finds probable cause for possession of fentanyl. Bond remains at $1,000. Possession of paraphernalia. Bond remains at $100. Thank you. Shaquanda Rochelle Davis. Ms. Davis, you were picked up for failure to appear, and bond remains set at $2,000 in your case. Thank you, ma'am. Patrick Celsus. Mr. Celsus, the court finds probable cause for possession of cannabis. Bond remains set at $250. Court takes no action on the other case that he was out on bond. Jeffrey Michael Sechel. The court finds probable cause for trespass on property after warning. Bond remains set at $500. The court finds probable cause for possession of paraphernalia. Bond remains set at $500. The court revokes ROR in the case. Defendant was previously out on bond, 2021 CF 11917AO. Counsel, yes, ma'am.
There was an offer to resolve the trespass and possession of drug paraphernalia.
Mm-hmm.
An adjudication of bill credit time served and no return. I would ask that since he's resolving that case, you take no action on the out on bond.
If he resolves it, yes, ma'am.
Yes, he's willing to resolve the.
Well, if that's the offer state.
Yes, it is, Your Honor.
Mm-hmm. And that will be with mandatory court costs, okay?
Yeah.
And then you're taking no action on that out on RR case, correct, Your Honor?
Mm-hmm. Right. No, the court is not inclined to accept this recommendation. The court believes probation would be appropriate, unfortunately. What's his history?
He has 2 felony convictions, 39 misdemeanors, 1 failure to appear.
Mm-hmm. Well, probation would probably not be appropriate, but more jail time than credit for time served.
Your Honor, I would act 20 days so I can let him decide if he wants to accept the offer.
I am looking again at the PC. How much time served does he have? 1 day? 1 day? 2? 10 days with credit for 2 days time served.
Yeah.
All right. How does your client wish to enter his plea to the charge?
No contest, Your Honor.
Mr. Satchel, is this your signature here at the bottom of this plea form?
Your Honor, if I may say something, I don't understand why if they came at me with an offer, now all of a sudden it's no good no more.
Because I refused to accept it.
I thought it was made by you, my apologies.
I didn't make it. They didn't consult me.
Nope, no problem.
Do you want to go forward with the offer or not?
Yeah,
Is this your signature at the bottom of this plea form?
it is.
Did you read the plea form before you signed it?
Yeah,
Do you understand that by entering a plea of no contest, you're giving up the rights on the plea form?
Yes.
Are you under the influence of any alcohol or drugs or medicine
No, I
today?
am not.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
I am a U.S. citizen.
You understand that?
Yes, ma'am. Your
The court finds there is a sufficient factual basis to accept your plea. You are alert, you're intelligent. As to count 1, trespass on property after warning, I will adjudicate you guilty. As to count 2, possession of paraphernalia, I will adjudicate you guilty. No further sanctions as to count 2. As to count 1, the court will order credit for time served, order that you not return to the location where this incident occurred, and that you pay mandatory court costs through the clerk's payment program. All court costs must be paid within 180 days, or your case will be referred to collections, and D6 will be ordered on your driver's license. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Sorry, it was 10 days, the court was, to amend, the court was ordering 10 days incarceration with credit for 2 days' time served. The court is taking no action on the 2021 CF 11917 AO case in light of the defendant entering the plea on this case. Jermaine LeVar Smith.
Behavioral, Your Honor.
Your Honor, we are going to ask to reset this for tomorrow, so he can see if he wants to resolve his case.
Case to be reset for 24 hours. Antonio Jermaine Tillman. The court finds probable cause for trespass. Bond remains set at $250. Court's ordering you not to return to the location where this incident occurred as a condition of your bond.
And there is an offer, Your Honor, from the state to resolve the case.
What is the offer?
A withhold of adjudication, credit time served, court cost, and no return, Your Honor.
State.
That is the offer, Your Honor.
The court will accept that offer.
I'm not sure if the no return was mentioned in there, but it'll be no return as well.
Thank you. Mr. Tillman, is this your signature at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it? Did you read it?
Yes, ma'am.
You understand that by entering your plea of no contest, you're giving up all the rights on the plea form?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medicine today? Do you understand a conviction on your case will subject you to deportation if you're not a U.S. citizen? There's a sufficient factual basis in your case. You're alert, you're intelligent. At this time, I will withhold adjudication of guilt, order credit for time served, order condition that you not return to the location where this incident occurred. You must also pay mandatory court costs.
Yes, sir.
Through the clerk's payment program, which must be paid within 180 days, or your case will be referred to collections, or a D6 will be ordered on your driver's license. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. Julio Hiram Castro Fibas.
Team medical, Your Honor.
Reset. Gracie Wells.
Mental health, Your Honor.
Reset. Matthew Edward Wolfrey. Sir, you were picked up for a violation of probation. Bond will remain set at $1,500 on count 1 and $500 on count 2. You have another case also for violation of probation. Bond will remain set at $500 on count 1, $500 on count 2, and $500 on count 3 in that case. All right, thank you, sir. Paul Clark.
Mental health, Your Honor.
Reset. Are there any other cases? All right. Court's in recess.
Thank you.